Good afternoon. I'm Judge Leslie Kim Smith. We are now live streaming on YouTube and on the record. Calling case number 240120092 Tony Fortune versus Citizens Insurance Company of the Midwest. Counsel, will you place your appearances on the record starting at plaintiff's counsel?
Good morning, Your Honor. David Eagles on behalf of Tony Fortune.
All right, and we also have intervening plaintiffs, Accurate Care LLC and Grossbeck RX LLC.
Good morning, or good afternoon, Your Honor. Mason Berry on behalf of the intervening plaintiffs.
Okay, and we also have Medcare Inc. doing business as Spinal Recovery Center.
Yes, Your Honor. Good morning, Rachel Wright, and on behalf of the intervening plaintiff, Spinal Recovery.
All right, and for defendant.
Good afternoon, Your Honor. Wesley Taylor, P86303, on behalf of defendant Citizens.
All right, may the record reflect I've had an opportunity to speak to counsel off record, as today is the date set scheduled for a settlement conference, as well for a hearing on defendant Citizens Insurance Company of the Midwest motion for summary disposition. I've had an opportunity to view the pleadings, and Mr. Taylor, if you're ready to proceed, you may begin with your motion.
All right, Your Honor. So even though the pleadings speak for themselves, I'm just going to give you a very quick and concise summary. So the record evidence shows that plaintiff Tony Fortune committed at least 25 verifiable acts of fraud, around 15 of which are relevant to her medical history when looking at the medical records from 2018 to 2023. Misrepresenting medical history is material to the claim because, pursuant to Rodriguez v. Farmers Insurance Exchange 223 Mishap Lexus 612, her medical history is relevant to causation and the determination of reasonable and necessary treatment related to said accident. And no juror could possibly find that Tony Fortune was unaware that she was submitting false information in her application, and falsely testifying to her deposition. Tony Fortune blatantly misrepresented her ability to derive income right after the accident because her MDDHS records show her deriving income from Mary Kay before and after the accident. Then last but not least, Tony Fortune blatantly misrepresented her claim history in her application for benefits and repeated the same fabrication during her deposition. This too goes to causation and the determination of reasonable and necessary treatment related to this accident. And I rest.
All right, thank you. And I received a response from the plaintiff.
Yeah, Your Honor, I won't go through 25 different counts for you, but really it sums up into two different things, and that goes to disclosure of prior medical conditions and disclosure regarding employment, if you really bring it into two categories. And if you look at her responses in terms of her applications compared to her deposition testimony, and I'm just going to go through a couple of them. Question 24 in particular, did you have same or similar injuries before the accident? Again, it doesn't have any temporal relationship there to time. It doesn't say at any point in your entire life, or also doesn't say right immediately before the accident. So Ms. Fortune indicated no in terms of that response, but that's based on a reasonable belief that a 2016 accident that caused a 2019 hip surgery with full and complete resolution of her symptoms. And one thing I'll point out, Your Honor, is if you look in defendant's motion, you're not seeing any records from before the accident or a year before the accident or 2 years before the accident. We're talking about years before with complete resolution and no evidence whatsoever before the court that there was like ongoing complaints where she would have or should have known that would have been relevant to answering that question. Same thing for question 25. List any medical conditions you had and or medications you were taking. Again, it doesn't say list every single medicine or every single condition you've ever had in your entire life. So once again, Ms. Fortune perceived that question to mean, did you have something that was ongoing or immediately before the accident, not historical information from many years prior. Obviously a clarification, and just to include in there, at any point in your entire life, we'd be having a different discussion right now. But that's not what the question indicates. It's left for interpretation. There's also another question. Have you ever made a claim for medical benefits as a result of a motor vehicle accident? Miss Fortune indicated no to that question. Her deposition, it was clear she completely forgot about a 2003 accident that occurred, which was 21 years before she filed this application with the MACP. She testified at her deposition that she couldn't recall any of the specifics about that accident or even any of her treatment. So the fact that she forgot something from decades prior, it's not all that surprising, and it certainly doesn't indicate fraud. When she was asked at her deposition about a 2016 accident and whether or not she made a claim as a result of that accident, since she had hip surgery from it, she testified, "I didn't hit anyone and nobody hit me." Again, showing that her understanding of what a claim means is synonymous with lawsuit, not medical providers who in the background are submitting claims on her behalf, but did you file a lawsuit? I mean, you can see her confusion there between claim versus lawsuit. It's an innocent mistake to a question on a form that she's filling out. A genuine failure to recall a minimal insurance interaction decades prior or an understanding of what's being asked, like claim versus lawsuit, certainly doesn't rise to the level of fraud, which requires a misrepresentation with the intent to deceive. Plaintiff cites to those 2016, 2019 records for her hip issues in a single neurological visit in 2019 for a new onset of headaches with absolutely no follow-up beyond that one single visit, which again, Miss Fortune just simply didn't remember. That basically is the summation of the alleged fraud as it turns on her medicals. Switching over to her work, Miss Fortune indicate that her daughter India took over her Uber Eats account immediately after. And I'll point out that, by the way, at the time of the accident, India was driving the vehicle that my client was an occupant of while they were doing Uber Eats together at the time of this accident when it occurred. So it's certainly not a stretch that her daughter India, who was driving when this accident happened for Uber Eats, happened to just take over her account temporarily. As to the Mary Kay records, it speaks for itself. If you look, what's shown on there is that my client every couple of months she's placing a minimal order in order to keep her account active with Mary Kay. That's her purchasing products from the company. It's not people actively purchasing them from her. You can see that it's a regularly scheduled order that happens about 2 months apart, so she can maintain in good standing with Mary Kay and maintain her access to the website also. So again, these are questions of credibility and intent, witness demeanor, reasonableness of my client's interpretations of the questions that were there should be facts that are left for a jury to decide.
All right. Mr. Taylor, is there anything else?
Yeah, I rebut a few points. So in terms of question 24, it's extremely straightforward. It's asking for, did you suffer the same or similar injuries before this accident? Now, before, I would think that's pretty straightforward. And it's just asking for like anything that happened from before the motor vehicle accident going back in time into perpetuity. There's no other way someone can construe that. And if the application as is was vague or ambiguous, as plaintiff counsel claimed, the Michigan Supreme Court would have held that is void for vagueness, and that ruling has never happened yet. But then as far as for knowing and intentional, only mere knowledge of falsity is required. You don't have to intend to defraud an insurance company. It's just the only thing that the No Fault Act looks at, and referring to the Bakeman opinion, is that you just put a false statement on the application for benefits or you made a false statement during litigation. Whether the person intended to do the same that has no effect. Then as far as for the medical history, on Glenda's application for benefits, she was claiming injuries to her neck, back, hip, wrists, and shoulders. And then and again, as we mentioned in depth, she indicated that she did not have any of these issues before on her application for benefits, and she repeated the same during her deposition. But the thing is, the records from Honor Community Health from January 25th and February 15th of 2019 completely disprove what she said in her application. And both sets of these records predate the date of loss by just around 4 years, which is very close to the accident. But then, in regards to the pre-surgical pathology necessitating injury, this sort of misses the point. We're looking at a hip surgery on October 4th of 2019, not the back or the right shoulder surgery. She still reported pain for 2 years post-surgery on February 2nd, 2021. That's also in the Honor Community Health records. And then the fact that she is still claiming the same, it really indicates that this issue really has not resolved.
All right, thank you. The court has had an opportunity to listen to oral argument. Plaintiff filed this action on August 21st, 2024, seeking first-party no-fault benefits arising from a motor vehicle accident that occurred on August 22nd, 2023. Plaintiff sought PIP benefits from the MACP, and defendant Citizens United Citizens Insurance Company of the Midwest was assigned to the claim. Defendant Citizens filed this motion for summary disposition pursuant to MCR 2.116C10, arguing that plaintiff made material misrepresentation regarding her claim, and therefore plaintiff and her medical providers are ineligible to recover benefits under MCL 500.3173A subsection 4. Defendant argues that plaintiff made material misrepresentation by failing to disclose her prior pre-existing conditions, the medications that she was taking, and included medical history dating back a number of years for hip, back, shoulder, thigh, right knee, and right ankle pain, and that she had a total hip replacement surgery in 2019. Defendant also argues that plaintiff failed to disclose the medications that she was taking and failed to disclose a prior motor vehicle accident that occurred in January of 2003. Based on further, that plaintiff failed to disclose that she needed assistance prior to the motor vehicle accident, and that she applied for Social Security disability. Plaintiff also failed to disclose that she was receiving money or earning from Mary Kay. Now, in plaintiff's response, plaintiff argues that the plaintiff did not misrepresent the information in her application. He argues that a number of the medical records are over 20 years old, and the fact that plaintiff may have forgotten, in particular, some of these, the motor vehicle accident that occurred in 2003, plaintiff testified that she doesn't recall the accident, doesn't recall any of the details of the accident. Now, under MCL 500.3173 subsection A4, it indicates a person who presents or causes to be presented an oral or written statement, including computer-generated information, as part of or in support of a claim to the Michigan Automobile Insurance Placement Facility or to the insurer to which the claim is assigned under the assigned claims plan for payment or other benefits, knowingly that the statement contained false information concerning a fact or thing material to the claim, commits a fraudulent insurance act, and would not be eligible for claims. Now, in interpreting the requirements of a fraudulent act, one, a person needs to present a cause to be presented by oral or written statement, a statement that is part of in support of a no-fault benefit, and the claim benefit was submitted to the MAIPF. I don't think there's any question in terms of that a claim was presented by written and oral statement to an MAIPF insurer who is Citizens, and that it was submitted to the MAIPF. The question, though, becomes the person must have known that the statement concerned false information. Now, defendant argues that plaintiff should have known these were prior accidents, prior medical conditions. But I think based on the evidence presented and the testimony of the plaintiff, I believe there remains a genuine issue of material fact as to whether or not plaintiff knowingly made false statements to the MAIPF. So for those reasons, the court is going to deny defendant's motion for summary disposition. All right, so the dismissal is for the reasons stated on the record, and I am now